Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin, beaming in from sunny and snowed in Calgary. I'm the managing associate of our Calgary, Alberta office, and I'm here today to take your questions, any questions you have related to employment law, any legal questions related to your employment. We're here for the next half hour to get through all of your questions, get you answers, so you know what time it is. We are beaming in from several different platforms. Feel free to put your comments or your questions in the comments section, and I'll get to as many of them as I can today so that you can have a bit more peace of mind knowing what your rights are with respect to your employment. It's been a tough few weeks, a tough few months now, actually, for the tech sector. A lot of layoffs have been announced, starting with, of course, we've all heard about what's been happening at Twitter, but Google has followed suit. Microsoft has followed suit. Amazon has followed suit. A lot of employees from one day to the next are being found or finding out they've been let go. And I've seen, by looking on my LinkedIn and things like that, not just very junior employees. We have long service employees that are being let go in this sweep of layoffs that we're having in the employment sector. And I have some of these tech workers reaching out to me with some very important questions. How is my severance pay calculated? Number one. So I want to just touch on this to start the show so people have a better understanding of what they're entitled to when they're terminated. So severance is calculated on two things. On one hand, it's compensation, and on the other hand, it's length of severance. All right. So in terms of compensation, when you're terminated and you're offered a severance package, say they offer you 6 months of severance, well, the basic rule is that that's 6 months of your full compensation, which of course means base salary, but it could also mean any number of things. Of course, benefits, vacation, bonus, car allowance, long distance allowance. We see a lot of that here in Calgary with the people working up in the camps will have a location allowance. That's included. Even though you're no longer going up to the camp, you're still entitled to the location allowance because it formed part of your compensation. So anything that you get compensated for, even your cell phone or a health spending account, all of that has to be included in the severance offer that's made to you. And then how long should that severance last, essentially? And that's the other question a lot of people don't know much about. There are people tell me, I heard it's 3 weeks per year of service. I hear it's 2 weeks per year of service. I hear it's a week per year of service. Which one is it? Well, in fact, that's not how it's calculated at all. All right. You have the right when you're terminated to have a judge determine how much severance you're entitled to. In actuality, a lot of these cases, the vast majority of them will settle well before they see a judge. But if it does get to a judge, what a judge is asking themselves is, how long has this person worked for the company? How old is this person? What was this person's title? And what is the availability of similar work? All right, so we'll go through those in turn. So what that means is all those answers to those questions kind of go into the judge's brain, and out of the judge's brain comes an amount of months of severance. All right. So the older you are, the longer your severance should be, especially if you're over 50. A judge will think that it'll take you longer than a younger employee to find new work just because of the way the system is. Length of service is a very important factor. Someone who's worked somewhere 30 years is going to get a lot more severance than someone who's worked there only 3 years. All right, very important factor. The title you have. Now, there's some debate whether this is still relevant, but in actuality, it still does come up. So if you're a vice president, if you're a senior director, if you're a manager, you might get more severance than someone who's a laborer or a cashier or something like that. The logic behind that is that those jobs are harder to find, right? There's not as many senior VP jobs as there are laborer jobs. So it might take you longer if you're a senior VP who's been terminated to find a new comparable job, all right? So that's an important one. And what economy are you being terminated into, right? as I mentioned at the start of the show, if you're a tech worker, everyone's laying off. It doesn't seem like anyone is hiring, right? So it might take you longer than it normally would to find a new job, which means more severance for you. All right. So what I try to tell my clients or my clients when they call me, how much severance am I entitled to? It's not like there's a law book somewhere that I can go and take a look and see Jane X is entitled to so much severance. It's not like that. A judge instead will look at people similar to Jane in terms of age, length of service, seniority of position, and availability of similar work, see what these people got, and give Jane something similar. And the judge is generally not giving 1 week per year of service. All right, that just is not what a judge will do, or even 2 or even 3. In fact, oftentimes, especially with shorter term employees, they're getting more than a month per year of service. And there's a maximum, we can say, of what you likely can get. If you've been there, you're 60, you've been there 30 years, you're a vice president, something like that, you're looking at 24 months. That's the top of the scale there. So, a lot to think about when you're reviewing your severance package. Am I getting what I think I'm entitled to? It's hard to know. We've distilled all of that information I've just relayed to you over the last 5 minutes. We've distilled it and put it into an online severance pay calculator. So if you want to just have an idea of what your entitlements are, visit our calculator. It's at employmentlawyer.ca. Employmentlawyer.ca has a lot of information for you, but if you want to go straight to the calculator, it's called pocketemploymentlawyer.ca. All right, pocketemploymentlawyer.ca. We'll ask you 4 basic, easy questions, and we'll give you an estimation of what we think you're entitled to. No obligation. If you decide that you want to speak to us after that, we're a click away for you to schedule a consultation so we can speak. So I always say this is a very important financial decision you make when you're terminated. You're not in the best of places. It's important that you take a second, pause, and see, you have an uncertain future ahead of you. Make sure that you have the compensation you need to get you through it. And so you want to reach out to us so that we can tell you whether you're entitled to more. All right. We had a few questions roll in. Let's get to those. So we have a question from Robert on YouTube. Should I receive any additional compensation if I have assumed a position as an acting manager for my company? So that's a great question. Yeah. So basically, a lot of people, they come to me, they say, well, I've been working for this company for 10 years. What am I entitled to? My last job, to use Robert's example, was acting manager. But my first job, to use the reference I gave before, I was a cashier when I started out. Now I'm an acting manager. What position is the relevant position to calculate the seniority of the position that I was just mentioning? Well, it's the position you had at the time of termination. Absolutely. Yeah. So if at the time of the termination, you were an acting manager, then basically we're going to treat you as a managerial employee. And generally, managerial employees will get more severance, all else being equal, than someone who's below a manager. All right, especially if you have direct reports, if you're getting involved with hiring and firing and things like that, that's a very clear indication that you're a manager. If you're approving timesheets, if you're approving schedules, things like that, that has an impact on whether you're a manager, because reality is judges are aware that there's some title inflation sometimes. But if you're a real true manager, then that entitles you to more compensation than you would otherwise. And the fact that you're acting is not all that important. All right. You get to be treated as a manager for the purposes of calculating your compensation. That's a great question, Robert. Thank you. All right. We got a question here from Philip Eno TV asking us, does your calculator include any additional factors like medical accommodation, arthritis? So no, Philip, the calculator really sticks to those 4 factors that I was mentioning. But you're right that in the eyes of the law, there are a lot of other factors that can be included. They're a bit more rare, but they're always relevant. All right. So for instance, the fact that you have arthritis, that you might require a medical accommodation to find new work, might mean that it'll take you longer to find a new job than someone who was otherwise not needing an accommodation, which can speak to how much severance you're entitled to. Absolutely. So there is a limit to the calculator. It's not going to be a perfect answer. It's not like you can take it to the judge and say, see, judge, this is what I'm owed. That's where the lawyers come in. Once you schedule a consultation with us, we can assess more largely all the factors that go into the calculation and see whether the estimate that you were provided by the calculator is accurate or whether you're entitled to potentially even more. Absolutely. So there's a lot of factors that go into it. You know, your level of education, for instance. I had a gentleman, for instance, that had been working 30 years in a manual job, so didn't have a lot of computer experience, hadn't looked for a job in 30 years, right? Now, you can imagine if you're looking for a job today, you need to have some computer knowledge. All the jobs are online, Indeed, LinkedIn, Workopolis. You know, you need to be able to access the internet to do that, right? So that's a factor, right? That explains why it's taking him longer to find new work, because you know, he hasn't looked for a job in 30 years. He doesn't know how to look for a job anymore, and he has to, you know, learn that skill again in a market that's completely different from the market where he obtained his last job, right? So these are factors that are important. Absolutely. So there's a lot of these different factors, you know, whether you were recruited from another company to come over to work will be a factor. Your level of education can be a factor. I mentioned the economic conditions can be an important factor in lengthening your lengths of severance. Absolutely. So a lot of things come into play. The four main ones, though, that everyone always has these is going to be they have an age, they have a length of service, they have a title or position, and they are being terminated into a job market, right? So everyone has these, and then other ones do get added on potentially. We have a question here from Carrie Smith. Can an employer request that you pay back a portion of your salary if you resign? So no. So basically your salary is earned compensation, all right? So you've earned that already, all right? So the fact that you resigned should not entitle your employer to say, well, you resigned, so give me 2 weeks back of pay or give me 6 months back of pay. It doesn't make any sense. You worked for those hours, so you're entitled to them. In fact, when you resign or you're terminated, you have to be paid your accrued vacation, your accrued salary and vacation at a very, very minimum. You could be terminated for cause. Doesn't mean you're not entitled to the salary and vacation that you've earned up until the day of your termination. Now, what I have seen sometimes is there might be agreements with an employer. For instance, an employer might provide a top-up to maternity leave benefits, or an employer might pay for your education. And the expectation the employer makes you sign is that you have to stay with them for a certain period of time. And if you don't, then you'll have to pay back, you know, either the top-up or the education allowance. So those can potentially be legal, are oftentimes not legal. So if that's the issue you're faced with, Carrie, feel free to reach out to us. We'll take a look to see if whatever the employer is claiming you have to pay back, whether that's enforceable or not. All right. So in terms of salary, no. If you've earned the salary, if you work the hours, you have to be paid. All right. So, but these other kind of additional benefits, it's more nuanced, and we'd have to look at exactly what you're referring to give you the appropriate answer. So if you have any questions, if you're still wondering, if you want to reach out to us, book a consultation and have a lawyer review your matter for you so you have a clear understanding, employmentlawyer.ca. The best way to reach out to us, go to employmentlawyer.ca and we'll be happy to talk. We have another question here from MM. If an employment agreement stipulates that only minimum standards is owed by an employer on termination, does that mean no severance? So you've touched on a great point. So what I was explaining earlier about how severance is calculated, that's if there's no employment agreement that limits you to less. So a lot of employment agreements nowadays, you start work, they'll make you sign an agreement saying, no matter how long you work for us, no matter what your position will eventually be, if we terminate you, it's going to be only according to the minimum that you're owed under a law in Alberta. It's called the Employment Standards Code. In BC and Ontario, it's called the Employment Standards Act. They're all very similar. They have minimum entitlements. So the clause that they have you sign is a termination clause that says if you're terminated, all you're entitled to is the minimum that you're entitled to under the Employment Standards Code. The minimum goes to a maximum in Alberta of 8 weeks. All right. So you could be somewhere 30 years. They can terminate you with two months notice. Not very fair. It's not clauses that we're in love with. And in fact, we've gone to court several times and invalidated those clauses. So a good proportion, I would say the majority of those clauses that we see on a regular basis are not legal. All right. And if they're not legal, what that means is a judge looks at the clause, realizes it's not legal, it's as though it didn't exist. All right. And if it didn't exist, you're back to being entitled to what I was explaining to you earlier in the show, up to 24 months of severance. So you can imagine you're looking at 24 months or 8 weeks. That's, as I was saying, a big financial decision. You want to reach out to us, have us review that clause, see if it's enforceable. Like I said, the majority of the clauses I see are not enforceable, frankly, the vast majority. All right. So definitely you want to reach out to us and have us look at that. Yeah, because there's a big difference there between 2 months and 24 months. All right. And oh yes, the other thing I'll tell you is some of these times these clauses are invalidated for reasons that maybe to someone who's not a lawyer or a judge are not that obvious. So you might read it and say, well, this clearly says that I don't get more. Have us review it. All right. Now, I think anyone will agree some of these clauses get invalidated on what the popular culture would call a technicality, but there's good reasons for that. So even though you're reading this saying, well, this seems clear to me, reach out to us. We want to take a look at that clause, let you know if that clause is enforceable, and if not, how much you're entitled to. All right. So don't be defeated by seeing that clause. It's very important. There's a big difference between what the minimum standard is and what your actual entitlement might be. A lot of money is on the line. You should reach out to us to review that. Now we have another question here from Grumpy60, Grumpy60 with the great name. If I get a new contract from my employer and they provide a consideration amount to sign the new contract, is there a formula used for this consideration amount? All right. So Grumpy is asking quite a bit of an advanced question for the show. So I'll just explain what consideration is. So imagine a scenario where you start a job and then 3 months later, the employer says, oh, by the way, we forgot to have you sign an employment contract. Can you sign this contract for us? And you sign the contract. And then years down the line, you're terminated, and they say, oh, well, here's the contract that you signed that, as MM was saying, has a termination clause that limits your entitlement. Grumpy comes to me with that contract and says, what can we do about this? The first thing I tell Grumpy is, well, you signed this after you started working, no consideration, which means you didn't receive anything in exchange for signing that contract, right? You should have received something of value for signing that contract. And the first thing I'll tell them is just keeping your job is not enough of something of value for that contract to be enforceable in the eyes of the law. All right. So oftentimes what an employer who's consulted a lawyer will do before giving you the contract is say, well, Grumpy, it's been 3 months. We forgot to get you to sign this contract. We're going to give you a signing bonus for the contract. All right. So you sign the contract, you get the signing bonus, whatever it is, $100, $500. And then 5 years from now, or whenever, Grumpy comes to see me with the contract, and he tells me, yeah, it was after I started working, but I got this $500. All right. Does that change anything? Well, it can, because now you've received something of value. There was an exchange of value. That might be an enforceable contract. So the question is, how much do you have to receive for it to be a legal exchange, a legal contract? Well, it really depends on a case-to-case basis. I've seen contracts where they offer 6-year employees $25. I've seen contracts where they'll offer you $3,000. Now, the first thing that I want to point out to Grumpy and everyone else in Grumpy's situation is you don't have to sign the contract, okay? I have a lot of clients that come and tell me if I don't sign this contract and take this $500, I'm going to lose my job. And they've been at the job for 20 years. I tell them you have more job security by not signing that contract, because without that contract, they probably owe you close to 20 months of severance. You have more job security by not signing the contract than by signing it. I've seen people with 20 years of experience sign the contract. Their entitlements went from 20 years to 8 weeks. Within 3 months, they're terminated with 8 weeks of severance. All right. Had they not signed the contract, the employer would have had to pay them 20 months of severance. And so the employer would never terminate them because they don't want to pay the 20 months of severance. So first thing to know is you do not have to sign the contract. They always say that you've had an opportunity to speak to a lawyer. It's worth speaking to a lawyer, all right? Because if you have 20 years of service and it goes from 20 months to 8 weeks, that's 10% of your entitlements. So you've lost 90% of your entitlements, which basically, say, on a $60,000 a year job might be close to $80,000 or $90,000 for the $500 they give you to sign the contract. All right. So between $90,000 and $500, which would you rather keep, right? So don't worry about the $500 signing bonus. Don't sign the contract. They won't terminate you, because if they terminate you, they'll owe you so much more than what they'll owe you if you do sign the contract. But the arguments that we'll then make to a judge, for instance, is $500 for Grumpy, who had $90,000 of entitlement at the time he or she signed the contract, doesn't seem like a good bargain, right? And so it can be that it's not enough, right? This is very case specific. So if you're in a situation where you signed a contract a few years ago and now you're terminated or relying on the contract, there's not a formula, Grumpy, is what I'm trying to say. But I will generally argue that anything below $1,000 is going to be not enough consideration, all right, for you for that to be an enforceable contract. I've made that argument several times. We've gone to the Supreme Court of Canada in our Uber decision on the concept that a contract can be unconscionable, that it can offend the conscience to enforce this contract. And this is one of the examples where that might be the case, where basically you sign away $90,000 of entitlements in exchange for $500. A judge might tell themselves, this is unconscionable, this contract. I am not going to enforce it. All right. So definitely, if this is your situation, don't think that your case is sunk. Definitely speak to us. We're used to dealing with these kinds of situations. Penny Tarrant asks, is there a statute of limitation to claim severance? Yes, there is. All right. So generally, you have 2 years from the day you found out that you were going to be terminated to sue. Okay. So, for instance, if you're told January 1st of 2023 that your job will end on February 1st of 2023, you have until December 31st, 2024 to sue. All right. You don't have until January 31st, 2025. The day you find out that your job is going to end is when the clock starts ticking, and you have 2 years from that. There are other important limitation periods that you need to be aware of. If you want to make a human rights claim, you have 1 year. You don't have 2 years. You have 1 year to make a human rights claim in the Human Rights Tribunal. Okay. If you want to make a claim for violation of the Employment Standards Code, for instance, here in Alberta, for instance, they didn't pay you your last week's wages, you have 6 months, all right, to make a complaint to the Ministry of Labor, all right. It is very hard to get around these limitation periods. I have people, constantly telling me, well, I had a death in the family, or I was on disability because of a mental condition, or, I had to go take care of my mother in another country, or that's not good enough. Okay. These are very strict deadlines. You have 2 years. You have to decide what you want to do. All right. If you're in a coma, maybe. Okay. But other than that, really, it's a problem. So make sure to get on that and reach out. All right. Now, I've talked a little bit about severance at the start of the show, and I want to end the show on what other entitlements you might be entitled to if you're terminated, kind of special entitlements. All right. So I want to talk to you about the what you get if you go to the Human Rights Tribunal. Now, if you're terminated for discriminatory reasons, and you go to the tribunal and the tribunal agrees that your termination was due to discriminatory reasons, the tribunal is not going to give you severance. All right. The tribunal is not empowered to give severance the way a court can. Okay. What the tribunal will do, the default, is to reinstate you into your position. Okay. The default is the tribunal member will say, here's your job back. All right. Now, what comes with that is the period between your termination and the decision from the tribunal, which oftentimes is over a year away. You'll get back pay for that. They'll say, well, you're going to get back pay, all the wages that you lost for being unemployed due to discriminatory termination. You'll get that, plus you'll get reinstated into your job. Now you have a job, you can earn a salary. Now, I oftentimes people tell me, well, listen, I don't want to go back to this place where they discriminated against me. Understandable. They probably don't want you back either. But they might, the tribunal might order that you receive compensation for giving up your right to reinstate, as well as your back pay and human rights damages. All right. So it's, of course, most interesting for people that haven't been somewhere a long time. Say you've been somewhere for 3 months, for instance, and you get terminated during your probation period for discriminatory reasons because for instance, become pregnant and need to take a maternity leave. All right. If you get terminated for that, and it's even if it's during your probation period where otherwise you wouldn't be entitled to any severance, well, you'll get back wages all the way to the day of your reinstatement from the day of your termination. Whereas if you could get severance, firstly, a probationary employee usually isn't entitled to any severance if they're terminated in 90 days. And there's a probation clause in their contract. So that person would be entitled to zero, might be entitled to upwards to a year of salary in back wages because they were terminated due to discrimination. So definitely something to think about. I have another question here, a follow-up question from Philip Eno. What if they place conditions, cannot make public any terms? So what if I disagree? That should not disqualify my entitlement. So, the thing about that, Philip, is a lot of people will get a severance letter that says, here's your severance offer. You have to keep it confidential. Even if that's the case, it doesn't mean you can't get legal advice. All right. A lawyer will keep your settlement details confidential, and the employer never means that you can't consult a lawyer. And if they did, then that would probably invalidate everything. All right. So very important to keep that in mind. All right. Penny Tarrant follows up. What if the employer provided one with no opportunity to negotiate severance? Well, if the employer isn't going to negotiate severance with you, you retain the right to sue your employer and have a judge determine how much severance you're entitled to. So in fact, it's not really in the employer doesn't decide how much severance you're entitled to. The employer realizes that you have legal entitlements to severance and tries to offer you as little as possible for you to give up that legal entitlement. All right, that's generally what the game is. And we come in and try to help you get as much as possible. And if the two parties can't come to an agreement, then we go to trial and have a judge decide, basically. But in actuality, I would say at least 99% of our cases, we're actually able to get the two parties to come together to agree to a term that everyone can live with. So that's why the lawyers are involved. That's why you speak to a lawyer when you're being terminated, when you're being provided with a severance package, because we can take this to the judge, have the judge decide if need be. But I want to assure you, I'm not exaggerating. 99% of our cases don't go to trial because it's not that hard to figure out. We just have to show the employer that we're willing to go to trial if we have to. And we do go to trial. I mean, we have much more than 99 cases in a year. So you can imagine we go to trial quite a bit. But in the grand scheme of things, the chance that your particular matter goes to trial is 1 in 100. June Lee asks, what right do I have when we've been put on temporary layoff? So June, you have several rights. So a temporary layoff is essentially a constructive dismissal, which means that if it's the first time you've been laid off, if you don't have an enforceable employment contract that says that you've given the employer the right to lay you off, then you can say, well, listen, I come here to work. I don't come here to stay at home waiting for you to call me. If you don't have work for me, then pay me my severance. All right. So if you want to do that, you have to do it promptly. Okay. You can't wait 2 years to say, well, actually, I was not cool with you laying me off. Pay me some severance now. You have to do it promptly. The moment you get laid off, reach out to us so that we can talk to you about what your rights are in terms of severance. Now, if you're wondering, Jen, well, what are my severance entitlements? You can visit our Pocket Employment Lawyer, the severance pay calculator, pocketemploymentlawyer.ca. See what you'd get if you had just been terminated. Likely that if this is the first time you've been laid off and there's nothing in the contract that allows the employer to lay you off, likely that what the Pocket Employment Lawyer is going to tell you is exactly what we would tell you in any case. You have a right to compensation. You have a right to severance. The employer doesn't have a right to lay you off. All right. So a lot of people think that it's like, I get a layoff letter. Must be that they're allowed to do that. They're not allowed to do that without your consent. If you don't say anything, then people will just figure that you consented. But if you speak up, you'll be owed severance. All right, we have another question here from MM. If an employment agreement stipulates that only minimum standard is owed by the employer on termination, does that mean no severance? I don't know what happened here, MM. I think I got that question from you earlier. And I think I addressed it earlier. So like I said, it does not mean no severance by any means. Reach out to us. You may have significant entitlements to severance, up to, as I say, up to 24 months of severance, which, do the math, can end up to being a lot of money for each of you. And I have some thank you here. Thank you from Grumpy60, from Carrie Smith, and from Perry Tarrant. Well, thank you all for Penny Tarrant, sorry about that, for jumping in today and answering these questions. We had some great questions from all of you today. It was a pleasure speaking with you. My name, once again, is Lluc Cerda. I am the managing associate, a senior associate here at Calgary, at Samfiru Tumarkin in Calgary, Alberta. We have another great show tomorrow. My colleague Madalena Visney will be joining at 12 p.m. Pacific time, 1 p.m. Mountain, 3 p.m. Eastern. Feel free to tune in. If there's any questions that you didn't get a chance to ask, she'll be there to answer your questions then. So thanks for tuning in, and we hope to see you soon. Bye now.